Ever wondered if you really need a power of attorney, a living will, and a last will and testament? Well, we'll tell you the surprising truth tonight on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. Tonight we're discussing why you or a loved one needs to talk about your final wishes, and you have to put it in writing. I have the pleasure of welcoming one of Toronto's most distinguished wills and estates lawyers and mediators into the studio tonight. We'll be speaking with Tony Baker, who not only sits as an adjudicator and presiding lawyer on the Consent and Capacity Board, but who also taught the principles of negotiation and mediation at various Ontario post-secondary schools. Welcome, Tony, and thank you for coming on. We are going to have a lot of calls today because there are a lot of things to cover and it's quite confusing. Of course, to our viewers at home, if you are at a position that you think you need to talk about a will, or you know somebody that does, you have questions about mental capacity or whether or not you need a power of attorney or what even a power of attorney is, please give us a call. We're here to help. So let's just answer those questions. A living will, a will, a power of attorney. There's different kinds of those. There's continuing. Tell us the difference. Start from the very top for us, please.
Okay, so generally, when I have clients coming into my office and they ask me about estate planning, the first document we talk about is the will.
Okay.
And the will has been around for a long, long time. Everybody knows that a will is a good thing to have. You appoint an executor, and the executor follows your wishes and distributes your estate as you direct the executor to distribute it. The other two documents, which arguably can be as important as a will, are the power of attorney for personal care and the power of attorney for property.
Yeah.
Now, if you don't have a will, the Succession Law Reform Act stipulates how things are distributed. So basically in Ontario, if you don't have a will, the first $200,000 goes to your spouse, and then the rest gets divided between your spouse and your children. If you have a power of attorney for property, you can appoint somebody to do things on your behalf while you're still alive. So for instance, if you are incapacitated, you're in the hospital, or if you're in a coma, you're alive, so you don't look to the will to see what happens after you're gone because you're still breathing. What you have to do is look at the power of attorney for property, and if you've appointed somebody to act on your behalf, they can pay your mortgage payments, they can fix your roof, they can do anything you can do with your money except make a new will. So a power of attorney for property, it's now called a continuing power of attorney for property, is a very important document, and I recommend that everybody have one of those because it's a safe stopgap measure for an unforeseen circumstance. Now, the power of attorney for personal care is a relatively new document that came into existence in Ontario in the 1990s, and it deals with healthcare decisions. So, if you want to appoint somebody to make healthcare decisions on your behalf, if you are again incapacitated, and the example I like to use is I have some clients who are Jehovah's Witnesses who don't believe in blood transfusions. And I've got one lady who's got a couple of daughters, and one of them is a Jehovah's Witness and one of them isn't. And she's appointed the one who is a Jehovah's Witness to be her attorney under the power of attorney for personal care, so that, God forbid, she's in a car accident, she's bleeding to death in the hospital. The doctor, if there wasn't a power of attorney for personal care, is in a classic dilemma because one daughter who isn't a Jehovah's Witness would tell him, you've got to give her blood transfusions. And the other daughter would say, no, we don't believe in that. You have to let God take her if we don't believe in blood transfusions, which we don't. So in this case, my client has appointed one daughter who is a Jehovah's Witness to make that decision on her behalf. Now, the living will, so-called living will, is an oxymoron, and in fact, there's no such thing really as a living will, because a will deals with what happens after you're gone. But the so-called living will is what I call a clause that we put into the power of attorney for personal care.
Okay.
So in my power of attorney for personal care, excuse me, there's a clause, and the living will is it's a healthcare directive, and it tells your healthcare providers, your doctors, etc., if certain circumstances come to pass, what your wishes are. So the classic term is no heroic measures.
Right.
Most people, most of my clients, they want to have a clause in there that says no heroic measures if the only thing that's keeping me alive is a machine, and my heart's still beating because a machine's keeping it beating, but in all other matters I'm basically gone. You can pull the plug, so to speak. It's a little grim, but that's basically what the no heroic measures living will clause in a power of attorney for personal care says.
Oh, that's a mouthful. And of course, if anyone at home has some questions, if they're looking at putting a will together, a power of attorney, they want to understand who they can appoint to take care of their estate, and also perhaps you're in a situation that you've been appointed as the attorney for someone in a situation, give us a call. I'll be happy to help you. So back to this whole living will, power of attorney. Now, when does a power of attorney kick in? So there's a common fear where people enter into a power of attorney and they feel, oh, I might as well have just given up all of my rights. Is that the case? What happens?
Well, as in most areas of law, we always start with a document. So we can tailor-make powers of attorney to fit different situations. Most people want what we call the continuing power of attorney for property. And the continuing part means it continues in the event of your incapacity. So you do a power of attorney for property when you're 40 years old, and then you put it in a drawer and you don't look at it again, and then you're 95 years old, life has gone by quickly, and you've got Alzheimer's disease. So you're incapacitated, you're incapable mentally. The continuing power of attorney is still a valid document. In the old days, they just called them powers of attorney, not continuing. And depending on how they were drafted, if you became incapable, the power of attorney became invalid. So most people don't want that. They want to do the power of attorney for property, and they want to appoint usually a wife or a husband or children. And it's valid as long as they're alive. As soon as they die, it's invalid. It dies with you. But what most people don't realize with a continuing power of attorney for property is the outside world can rely upon it. They don't have to look behind it. So if you do a continuing power of attorney for property, and I've had this situation where a mother has a son who
And we've about 90 seconds, just
Okay.
to keep that in mind. Go ahead.
Okay, she appoints her son who she trusts implicitly, and it turns out the son has a few nasty habits.
Oh dear.
And he goes to the bank and he cleans out her bank account, and there goes her old age retirement plan, and she doesn't even know about it.
She wasn't in a position of being incapacitated or anything like that.
No, because the bank, they see it and they can rely upon it. So if somebody has a power of attorney for property, it's probably the most powerful document in all of common law, and banks have to accept it, financial institutions have to accept it, and it can be abused. So that the key is you only appoint somebody that you really trust, because it's open to be abused.
Could you, we have about 45 seconds.
Okay.
One question that we'll get back to. I want to know, how can we limit that authority? Maybe perhaps the ways not to tell the person that you've appointed them, and so on. And we'll think about some of those questions and those problems. And of course, if there's anyone at home that has any questions about what to do if they're drawing up their will, where they can find these documents, if they are appointed as someone in the power of attorney to take care of somebody, their property and so on. If you have any questions about that, please give us a call. We're happy to help with Tony Baker. So one quick question.
Okay.
Oh, actually, you know what?
Okay. Break.
We have only 8 seconds left,
Okay.
so we'll get back to it.
Okay.
And we'll be able to answer some more of those questions later on. Of course, when we come back, you'll not only watch lawyers do something incredible, give away legal advice to no bill, but you'll also get the insider tips you need to help your family avoid a legal battle. Welcome back to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. We're joined today by one of Toronto's best wills and estates lawyers, Tony Baker, and we're answering your legal questions about what you need to do to protect yourself if you get sick and to protect your estate. Of course, if you're in the position right now where you have to consider drafting up a will, a power of attorney, if you're appointed to basically direct as an executor of an estate, please give us a call. We're happy to help. We're happy to answer your questions on anything to do with wills of the estates. Back to the earlier question though, so are there any preventative measures that you can put in place if you have a power of attorney for property and so on to make sure that nobody does abuse it?
Yes, you can limit it. By way of example, I have in my law practice people that buy and sell property, they buy a cottage, and they may be out of town when the deal closes, and so things have to be signed. And they'll routinely appoint me as a power of attorney, as an attorney under a continuing power of attorney for property, and we'll say that this power of attorney becomes null and void, you know, the day after closing, for instance. And again, you always look at the document to see if there's any limitations in it, whether it's limited by time or whether it's limited by this person, you know, provided they're under the age of, you know, 30. You can, like I say, tailor make it.
Can you appoint just about anybody for your power of attorney, personal care or property?
Yeah, as long as they're over 18 in Ontario. And remember, all of the subject matter that we'll be talking about tonight related to real estate or attorneys under property or personal care, it's only for the province of Ontario. So each province in Canada has different legislation. Some of them are similar, but anything that I'm talking about is only relevant for Ontario's purposes. But sorry, what was the question again?
No,
limiting it.
Yes, limiting it.
Yeah, I mean, you can, it depends. The general rule is you want to have, it's kind of like a security blanket. So generally most people want to have somebody that they trust, a spouse or a child, and they want to leave it unlimited so that there'll be no restrictions, because if they trust them implicitly, why would they want to restrict it? But if, like I say, you want a professional person to be your attorney for a limited purpose, it's easy enough to draft it just to limit it that way.
Okay, so there's some things that you can put in there. Or also, of course, there's a powers of attorney for personal care that only kick in when someone becomes mentally incapable. Is that the case?
Again, you could limit it. They don't call it a continuing power of attorney for personal care. It's just called a power of attorney for personal care. But the power of attorney for personal care would only be used if you were incapable. So the law in Ontario is a doctor can't touch you without your consent. So if they want to give you a blood transfusion, or you see it in, you know, psychiatric wards, do they want to give people shock therapy? They've got to go to the patient first, and the patient says either yes or no.
Right.
And then if a doctor thinks that that person is incapable, that they don't have the ability to understand the consequences of their decision, if they're declared to be incapable, then the power of attorney for personal care would appoint the person to make that decision on your behalf.
Well, what happens is, for example, I've seen this happen a lot, and I'm sure some of our viewers at home have the situation where a parent already has Alzheimer's or has some sort of mental dementia issue, and they don't have a power of attorney for personal care or property or even a will. Can they create one at that point?
No, not once. Well, any lawyer that drafted a document and had it signed by someone that was incapable shouldn't be practicing law, because that's gross negligence.
Oh dear.
If somebody comes into my office and wants to sign one of these documents, I ask them, I have a whole list of questions to make sure, in my view, that they're capable, that they're understanding the consequences of what it is they're trying to achieve. If someone is found to be incapable regarding the management of their property, immediately when that capacity finding has been found, the public guardian and trustee becomes the substitute decision maker.
Oh, okay.
If there is no power of attorney out there.
Okay.
If there is a power of attorney out there, the attorney named in the power of attorney becomes. So it's a hierarchy. So the power of attorney named in your power of attorney for personal care trumps the public guardian and trustee. But if there is no power of attorney for personal care, the public guardian trustee steps in.
Sorry, go ahead.
And they become what's called the guardian of property.
Yeah.
And generally what they'll do, though, is they're a very, you know, they're a good organization, and they'll work with the family to determine who basically should be carrying the ball. Everything legally will go through the public guardian trustee, but they'll draw up what they call a management plan.
You know, before we go there, we have someone patiently waiting on the
Okay.
line for us, but we're going to have to get back to that because
Okay.
I want to talk about next is what happens if nothing is in place.
Okay.
So thank you so much, Mike, for holding. Mike, go ahead. We're here to answer your questions.
Hi, Tony.
Hi, how are you, Mike?
Go ahead.
Great, and yourself?
Good.
I'm just kind of curious what would happen in the situation where, in a will, a person leaves an asset that's depreciating, and then at the time of their death, you know, let's say it's a $500,000 sports car, and then at the time of their death, it could be worth little to no value. How would you administer the estate in that situation?
Okay. So it has to do with the depreciating asset, Mike, and your question is, when it's a depreciating asset, how do you administer it? Does that have to do with a valuation issue?
I guess, yeah. Maybe Tony could help me out with that one.
Okay, so I don't want to get too complicated, but not every asset has to be so-called probated. We're not even supposed to use that word anymore because it's a Latin term, but everybody still uses it. So the basic idea of probate means true in Latin, and for certain assets, real estate, for instance, stocks and bonds, you can't transfer those assets unless you go through the probate process. So you have to have a will probated. It's now called, in plain English, lawyers are supposed to use plain English in Ontario, it's now called a certificate of appointment of estate trustee with a will. So if there's a will in place, the document that you get is called a certificate of appointment of estate trustee with a will. If there's no will in place, it's now called a certificate of appointment of estate trustee without a will. It used to be called letters of administration. At any rate, what goes through the will, if there is a will, and we'll assume there is one in this case, is everything which is in the deceased person's name alone. So if they have a joint bank account with a spouse, it doesn't even make it to the will. We look at each asset individually. And if this car that you're talking about, I mean, it's conceivable it could be jointly owned, in which case it would pass to whomever it was jointly owned with, and you wouldn't even have to look at the will. Mm-hmm. If it was in Joe Blow's name alone and you wanted to transfer it, I don't think, and let me think for a minute, you wouldn't have to have that asset probated. You could just go to the motor vehicle branch and show them a death certificate of the person who's died and show them a copy of the will, and if you're the beneficiary under that will, the Ministry of Transportation would transfer that asset to you without having it probated, so to speak. A lot of people nowadays are doing two wills, and this is a whole kind of a new area. And in one will, they put everything of value that you have to have probated. So they would put their house, they would put their stocks and bonds and mutual funds, etc. But a lot of assets you can just transfer. If I owned a Picasso painting and I wanted to leave it to Natalka in my will,
thank you. Yeah.
She would just get it. I mean, she just gets it, and there's nothing. You don't register it like a piece of property. You register it under the Land Titles Act. So what some people are doing is what they call a primary will and then a secondary will. And the reason they do that is if you had a Picasso painting, for instance, which is worth, let's say, $1 million, the estate administration tax on that would be about $15,000, which you would have to pay if you just had one will. What the government does is they add up the value of all of the assets, mm-hmm. regardless of whether you even need to have each individual asset in probatable form, and you pay a fee based on that. But if you separate the wills and you have a primary will and you pay the estate administration tax based on its value, and then in your other will you have jewelry, let's say, I can't really think of too many other things.
Cars?
Well, the car, you could have
Yep.
the car because Yeah, no, I don't think the Ministry of Transport requires you to have that probated. Then you would save the 1.5% basically estate administration tax on all of those assets.
And we have some more callers coming in right now, so I want to make sure we get to them all. Is there something, so with Mike, he doesn't need to value the asset at all?
I don't think so. I mean, if there's other things in the estate, such as stocks, bonds, mutual funds, real estate, he's kind of stuck because the Government of Ontario wants the lawyer, when the lawyer fills out the application, the so-called probate application, to add up the value of all the assets. And when I'm doing that, I get an appraisal or two for everything. And I would have to have something. I mean, you could drive the car to a dealership and say it's for probate purposes, and they could give you a value, and then you've got a piece of paper, and
They could bring that back to the lawyer?
yeah, and that would go into your list, and you'd have to pay a tax on that to have the whole will probated, because that's one of the assets. But as far as actually transferring that asset, you wouldn't have to show the ministry a certificate of appointment of a state trustee. It's a little confusing, but the bottom line is you don't need to have the car in probatable form in order to transfer it at the ministry.
Okay, great.
A death certificate would be good enough.
Okay, and then also as far as valuations go, again, just to reiterate, you just go to the car dealer and they can do that themselves. You don't have to get something professional done. Mike, does that help at all?
Yeah, that was a great answer. Thank you so much.
Thank you. You have a good day. And of course, to our callers, continue to call in. We've got a lot of people calling in and we're happy to help. So hopefully we get to everyone today. Chris, you're up, Chris. Hi, Chris. Thank you for
Hi,
holding.
good evening. How are you?
Good, thank you for holding. How can we help?
My question is regarding the power of attorney.
Absolutely. How can we help you with that?
What if a parent becomes not able to make a decision, and there's two people under the power of attorney, and the two people that are appointed are not getting along?
Oh, that is
What happens in that scenario?
good question, Chris.
Thank you.
Tony, go ahead.
Okay, well, that's a problem. Are we assuming then that a power of attorney has been drafted and signed, and mom has appointed her two children as co-attorneys under the power of attorney?
Exactly, sir.
And this is a continuing power of attorney for property?
Correct.
And they can't decide what to do. That's a problem. The short answer, the expensive answer, is they're going to have to go to court to get directions, and the court will tell them what to do. A better answer is to try to mediate it. There's all sorts of mediators around. You could try to set up a mediation who would basically tell you, why would you want to spend money on lawyers going to court and watch your mom's estate get dwindled when you can be reasonable and try to negotiate something to deal with how does one party want to transfer an asset? Typically we see something where mom's on her last legs and she's still alive and she's got a cottage up in Muskoka, and the two kids are fighting because one of them wants to keep the cottage and the other wants to sell it for the cash or something like that. I don't want to probe too deeply or pry into your personal affairs, but it's a matter of negotiation, and if you can't negotiate, then you try to mediate, and if you can't mediate, then you have to get the court to make an order.
Can Chris, let's say they try the mediation route and they have to go to court. Can they make these applications themselves? Do they have to go through a lawyer?
They'd have to go to Superior Court, and they could try to do it themselves, but I'll tell you, Superior Court's a complicated place to go for the uninitiated. I mean, some people do self-represent.
Okay.
But I don't do a lot of litigation in my practice. I think if I have to be involved with court, I haven't done my job properly, which is to try to enlighten clients of the wisdom of negotiating settlements. There's no magic in making a court impose a settlement on two reasonable people who should be able to manage their own affairs. They know more about the subject matter than a judge is going to know. And I just think it's the last case, worst case scenario to have to do something like that.
Absolutely. Chris, does that answer your question as to the next steps that we'll have to go on?
It does, but I have a very important question.
Go ahead.
On the same topic,
Absolutely.
what if one of the power of attorneys that was appointed has been taking care of these properties for 20 years and the other one's done nothing? Does that help at all in the power of attorney of who can make that decision?
That's a good, excellent point.
Well, that would be evidence that you would argue in court to try to get the judge to appoint you as a sole attorney under the power of attorney. I just want to backtrack just for a second, though, because there's two words that are very important in this whole area, and those are the words jointly and severally. So I'm assuming from what you've told me, and again, most lawyers don't like to give advice unless they have the document in front of them and see the words. Usually it's my practice when two attorneys are appointed, I usually put the words jointly and severally in. So I have two daughters, for instance, and if my wife was gone and I was still alive and my daughters looked at the power of attorney that I've drafted regarding me, it says I appoint the two of them jointly and severally to make decisions on my behalf. Now what that means is either acting alone or together. In a perfect world, both of them will be in agreement. But legally, either one of them has the authority. So if your power of attorney for property says the words jointly and severally, and I'm assuming it's your sibling that you're appointed with, legally either one of you can act under that.
By themselves.
By themselves. So if there's a house, legally either one of you could sell that house.
And the other person couldn't prevent them from doing anything.
Not legally. They could then, if it was a breach, if they were abusing it and profiting, they would have an action against you. But they couldn't prevent the sale of the house without litigating it and putting a caution on property.
Okay.
So
they would have legal recourse.
Yes, I mean you have to go back to this idea that you're not supposed to look behind the document. The document confers the authority, and if you are abusing it, even though legally you make the transfer, but you put that money in your pocket and half of it's supposed to go to your sister, she can come after you, and it's very serious. It's breach of trust.
We are going to have to wrap
okay.
up the call with Chris. Sorry, Chris, but so that would be able to help him convince the courts that he should be the sole decision maker.
If he's been managing, yeah, I mean that would be his good evidence to show that he's been carrying the lion's share of the load, and he would be a better attorney for his mom because his sister's being unreasonable. But
or
again,
doesn't have the experience.
Yes.
Oh, wonderful.
But that's last case. Worst case.
Worst case. So Chris, first try to negotiate, mediate would be the next step, and then finally going to court and then bringing the evidence that you should be the sole attorney because of your experience and knowledge on the matter. Chris, thank you so much for calling. We do have to move on as we have a lot of people calling in. We want to make sure we help as many people as we can. Of course, to our viewers at home, keep the calls coming in. Hopefully we'll get to you. Mary, how can we help you? You're up.
Hi, how are you?
Good, Mary. How are you doing? How can we help?
My family member had Alzheimer's and was diagnosed with Alzheimer's, and it was after that they had made the will, even though they were diagnosed with Alzheimer's and dementia, and a lawyer did make a will and made a power of attorney for this family member. Now, we feel that this is not right because we know for sure that their practice was taken away from them. The license was taken away from them, and the doctor, diagnosed them. So, what recourse can we do? Should we go to a lawyer or should we go to public guardian? And the power of attorney. And it's not a living will. That's what he told us. And he said that we have no say in any family matters because he is the power of attorney. So I'm just wondering, is there anything that we can do? Because he sold the house without even letting us know that was done. Wow. So we would just like to at least be involved in or having a say in some of the family matters before he sells things. I mean, is that allowable if he's the power of attorney?
Great question, Mary.
Okay. again, I'll make some assumptions because you threw a lot of information out there. So the lawyer who drafted the powers of attorney and the will has since been disbarred. Is that what you said?
No, no.
The doctor, was it?
The family member had Alzheimer's, but after he was diagnosed, he went to a lawyer and had a will and a power of attorney drawn up, and we knew that our family member was not capable.
Okay. Well, capacity it's a very difficult thing to assess. And I mean, I have clients who do have Alzheimer's, and they have good days and bad days. And one day they can be capable, and another day they may not be capable. Most lawyers are careful. Most lawyers that practice in this area are very wary of situations like you're addressing right now. And we have errors and omissions insurance for negligence. And if somebody is negligent, they're liable. Now, the problem is, how do you prove the negligence? And I'm very careful. If somebody comes in to see me and I have any doubts whatsoever of their capacity, I always err on the side of saying, sorry, I don't think I can take instructions from you. I don't think I can do a will for you. I don't think I can do a power of attorney for you. You know, there's lots of other lawyers out there. You're welcome to try one of them. I'm just not your guy. But if they want me and they persistently want me to go ahead, and I think that on another day they may be capable, and they do come in on a day when they seem to be quite capable to know what it is they're doing, I'll make very copious notes. I'll ask them very precise questions, and I'll have a file there, and I'll say, look, when Mom came in to see me, she knew she had $800,000 in the bank. She knew she had 3 children. She knew that she didn't want to treat them all equally because one of them had won the lottery last year. She knew she had a house in Muskoka. Yes, she had Alzheimer's, but Alzheimer's doesn't 100% mean she's incapable.
Can Mary ask for that documentation to give herself some comfort as to knowing whether or not this family member was incapable or capable during that time period when they made that power of attorney in the will?
Well, I think the short answer, the best answer, is she should go to a lawyer. And any lawyer can get documents from another lawyer. And, you know, if a lawyer suspects that another lawyer has been negligent, they have a duty to notify the Law Society, and we have errors and omissions insurance to cover us. And it may be that she does have a claim, and it may be that there's money out there to compensate her for any loss that she should have got had the documents been drafted correctly.
Is there anything that she can do to stop the individual right now from making the sales, doing what he's doing underneath the power of attorney and all those powers that he has?
It sounds like he's already sold the property. She said he already sold. Did you
But
say
is anything else that they can prevent him from doing?
Well, there's a thing called a notice of pending litigation that she can register. If there's any real estate in the estate, she can register that on title.
Okay.
And that way the property can't be dealt with until this litigation has been settled. But she definitely needs a lawyer to do that.
Okay, Mary. Mary, thank you so much for your call. So perhaps what you need to do is you do need to get a lawyer to really delve into the details here. There are options for you to put notice of pending litigation if there's any more real estate left. And then also delve deeper into whether or not there was evidence, although you know that he wasn't capable at that time, if there was any evidence during that exact moment that this family member was making that power of attorney or that will, that he was incapable at that exact moment. We do have to wrap up because we have a lot more callers coming in.
Could I just add one more thing
Absolutely.
to that? So if the estate also hasn't been finally wound up, you can also file a claim. It's in Toronto, it's on University Avenue at the Estates Court, and if that claim is filed, they'll be able to tell you if there was a certificate of appointment of estate trustee issued, and if there was, you can file a claim, and that gives notice to whomever the executor is that they can't do anything more with that estate until this claim is dealt with. So there are some remedial measures to take, but without having more specifics, I'd be negligent to give you more specific advice, I think.
Well, at least we have some direction
Right.
and advice that, you know, they can't do something.
Yeah.
We're moving on to our next caller,
Okay.
though, and that is Eduardo. Eduardo, thank you for holding. Go ahead.
Yes, thank you. My question is a bit complicated. My father, we are from South America, right? And my father passed away about 12 years ago, or almost exactly 12 years ago. And one of the things he left us, my sister and myself, is a certificate of deposit in a Canadian bank in US dollars. He left a will in South America where his estate has to be divided exactly half and half, my sister and myself. Now, I've talked to the bank. First of all, I've read somewhere that banks have the capacity of accepting a foreign will because the legal process here in Ontario is rather expensive, and the legal fees from lawyers would be hefty too. So my question is, what can I do? Because I've talked to the officer in the bank, and I just had bad luck, and the person didn't help me much.
Okay.
What can I do so that the bank takes that will into account? Because the other alternative was something to do with auxiliary, sorry, probably ancillary. I remember those two words.
Okay.
How can you help me?
Sure. So this is interesting. An international issue.
Okay. Did you say ancillary?
Yeah.
Yeah. Okay. I'm thinking that in the old days we used to call it resealing, but I think they call it an ancillary probate now. So generally speaking, wills from foreign countries are, you get, like in South America, I don't know what country it is in South America, but I'm guessing you would get what we used to call letters probate in Canada. You would get that issued in the country of origin. Let's say it's, I don't know, Argentina. And then when you come to administer the assets in Canada, the certificate of deposit at the bank, there's two options. You go to the bank like you've done so far and you ask them to act on it, but it's their call. And they can refuse until you show them Ontario probate or a certificate of appointment of a state trustee. And to do that, what the government of Ontario does is they basically look at the will from South America, and they basically, in the old days they called it, they resealed it. So they put an Ontario seal on top of an Argentinian seal so that it's valid in both jurisdictions. The reason that banks are getting more gun shy is everybody's worried about liability and fraud nowadays. Since the internet, fraud has exploded everywhere. And in, you know, a generation ago, I'd say half of the wills that I dealt with had to get probated, because you used to be able to take an original will to the bank and show the bank manager and say, this was my dad, here's his birth certificate, here's his death certificate, this is me, here's my driver's license, I'm the executor in the will, please transfer to me, and they would do that. Now they're worried because if they transfer that money to you and it turns out that your dad did a more recent will, he found religion the day before he died, and nobody found that will until after the Argentinian will had been probated, factually, the most recent real last will and testament leaves everything to the Red Cross, let's say, and it shouldn't have been distributed to you and your sister, then the government of Ontario is on the hook, and they would have to pay the Red Cross.
So that's why they're being a bit more cautious. Is there anything that Eduardo can do in order to support his position? And it's not, Eduardo, do you have you made an application, an estate application, or have you gone down that route?
Sounds like he got
I tried to do it, and I calculated, and it was a hefty payment for the courts.
Yeah, to the state administration tax.
Not even, I haven't even found out the cost of the lawyers, which probably would be hefty too.
Yeah, it'd be
for
1.5% of the value of the
protect
estate.
the assets.
Okay.
But if it's a certificate, I'm just thinking, we take this one step
we
at a
have
time.
to-
So we have to look at whatever the asset is, and if the asset is a certificate of deposit, and you're the one that's named as the beneficiary of that, I mean, I think the bank should transfer that to you. It shouldn't even have to go through the will. What goes through the will are things like I say, real estate and other things. But if you're the named beneficiary, I would think the bank would transfer that to you. And if they don't, I would go to see a lawyer. Quite often a lawyer's letter will do it. I mean, I do this all the time, where a bank, isn't that friendly to my client. Are we wrapping up?
We have to wrap up this call because we have so many people.
Okay.
But what Tony, perhaps what Eduardo can do, a less expensive route then would be to go to a lawyer to get a letter. You were saying.
Yeah, quite often I'll review it, and if my hunch
Okay.
is correct and I wrote a letter, quite often the bank would be enough to do it. Because then they've got a letter from a lawyer in case they're on the hook. They say, well, Baker told us we can do it. And then because at the end of the day, lawyers in Ontario have errors and omissions, and they can come after us, and we get sued.
So Eduardo, next is to go to a lawyer, get that letter, because it doesn't seem that the application is necessary if you're the beneficiary. Thank you so much for your call, and best of luck. Alan, go ahead. Alan.
Oh, hi there. Thank you for taking my call.
Thank you, Alan. Go ahead.
My father passed away a year and a half ago at the age of 75 from Alzheimer's. In the last 3 years of his life, he spent in a nursing home. I have one sibling, my brother, who is the co-executor with my father's second wife. And the reason for the call is my father had a place in the United States in Florida, and he also had a place up north here, east of Peterborough, worth about $600,000. And apparently my father's house is worth about $600,000, and he was going to give my brother and I each a third, and her children a third.
Okay.
And in the last, hold on, sorry about that.
That's okay.
In the last bit of his life, the last 2 years, 3 years here, they took $137,000 out of his RRSPs, as well as putting a $400,000 mortgage on the house in the last few years of his life.
Oh, wow.
So I don't know what to do. My brother is co-executor, and he doesn't want to contest the will because he believes that she could sell it for whatever she wants, and then we would be stuck with what's left over.
Okay, so some interesting questions about co-executors as well as what the rights of the wife are, et cetera. So Alan, we only have a couple of minutes to get this through, so Tony, you go ahead.
Okay. Again, we've got to look at what the will says, and if the will appoints I guess it would be your stepmother and your brother as the executors, they're really driving the bus. Unfortunately, you're a potential beneficiary and you can assist your brother, you can give him moral support, but legally it's up to them. I don't know if your stepmother is in Canada or if she's in Florida. I don't know if the will drafted in Florida or was it drafted here in Ontario? Do you know?
Drafted here in Peterborough.
Okay, so yeah, there's assets in the States which are going to have tax consequences as well. Does your brother and your stepmother get along? Do they get along with each other?
My brother and her?
Yes.
They were getting along, and then apparently after my dad died, Errol, my brother, asked her to show, why she took this money, and could he see her will, and she basically said, "You better stop bothering me, or I'll write you out of my will too."
Yeah. Well, again, going back to what we said to an earlier caller, I mean, at all costs, you don't want to end up in court. When you end up in court, the assets go so quickly because lawyers are so expensive and everybody has their own lawyer and you've got 3 or 4 legal fees to pay. If the two of them can agree on who the lawyer for the estate should be, I mean, quite often in a situation like this, if your brother and your mom agreed, your stepmother agreed that, not that I want to be the lawyer in this case, but if they agreed on me as the lawyer, I would get them into my office and I would read them the Riot Act and I would say, look, you've got to settle this thing, and it's in everybody's best interest to take a deep breath and go through all the issues one at a time and try to administer this estate the best way we can. And you look at the terms of the will. It's really not rocket science. I mean, the terms of a will, if you follow them, it'll say, I pay off all my debts, I leave, you know, this property to so-and-so and this property to so-and-so. Whatever's left over gets split amongst the three of them. And you just take it one step at a time and try to keep any animosity and rancor down to a minimum. There's a lot of issues there that you've talked about. When you're the executor, you're the legal owner of the estate, and you can sell the property. Now, if you're putting that money in your pocket when you shouldn't, then again, that's breach of trust, which is serious.
And is there any evidence that Alan could gather? We only have about 30 seconds to wrap up before our break, that Alan can gather in order to support any potential negligence or breach of trust that's happening here?
Well, he'd have to. I mean, the executors within a year are supposed to account, and they're supposed to show all the money that came into the estate and all the money that went out of the estate.
Okay.
It's called a passing of accounts, and beneficiaries have a right to have accounts passed, and they can apply to court to have that done.
You know what? Then that would be probably a solution here. And of course, mediation, Alan, is always the best solution before you go to court on this. And of course, when we come back, we will continue to help make the law a little less murky by answering your wills and estates questions and helping you protect your rights even after you're gone. Welcome back to Toronto Speaks Legal Advice. I am your host, Natalka Falcomer. We are joined today by wills and estates lawyer Tony Baker. And before the break, we were discussing your rights and how to avoid common legal mistakes that arise when you are preparing your will and power of attorney. And we did have two people that were on the line patiently waiting, so we'll go right to it. Mike, how can we help you? And thank you for waiting. Mike, go ahead.
Yes, hello, good evening.
Good evening. How can we help you?
Yes, thank you. Actually, I've got two questions. The first one is, could you explain to me with a little bit of detail, or as much as you can, what a Henson Trust is? I have a family member that is on permanent disability with on a sort of a federal pension, and I just wanted to know what the parameters of that are and what's involved. And then, secondly, actually, well, let's get that one done first.
Good call. Go ahead.
Okay, so a Henson Trust is named after, there was a fellow named Henson, and his son was disabled, and it's what you do when you set up a Henson Trust. The idea is, if a child is getting disability payments from, I guess, Canada Pension Plan Disability Division, and that child inherits something under a will, often they will lose their disability payments because the government will deduct. They'll say, well, I mean, the whole nature of our social scheme is to help people who don't have any money, and they'll say, he's got money now, so we're going to cut back on those payments. So the idea of a Henson Trust is to appoint a trustee to, while the child is alive, administer the trust and basically dole out. So let's say the child is getting $1,000 a month disability payments, but and they have some exceptions as to income they can earn on top of that. So, and I'll make up figures because I don't know exactly what the figures in the law are, but let's say he's getting $1,000 a month and the law says he can get another $500 a month and it won't jeopardize the $1,000 a month he's getting under disability. What the trustee does is he takes the money that's inherited and puts it in a GIC or whatever, and controls the amount of money coming out of the instrument that's been invested, so that he gives the child $500 a month, and that way the child gets the maximum benefit possible, and the capital is kept in the estate, so when that child dies eventually, the residue of the estate goes to grandchildren or other beneficiaries.
As outlined in the person's will.
Yeah.
Does that answer your question, Mike? Because we do have limited time. I want to make sure we push out those questions for you and get those answers.
What the term is like as an example, my mother has some GICs that are in a bank, and I have rights of survivorship on the GIC, so it's basically a joint account with rights of survivorship. What does that really entail, and what is that really about?
Well, that would be an asset if your mom, God forbid, were to pass away. If you have the right of survivorship, that asset does not go through the will. You get that before it even makes it to the will. So I have many cases where a husband and wife will come in and they're elderly, and the husband dies first, let's say, and his estate is actually very minimal because the house is jointly held, all their bank accounts are jointly held, and everything goes automatically to his wife if she's a joint and several owner of these assets.
Without the probate, without the whole
Doesn't
entire
even go
process.
to the will. So what's in the father's will in this case, or the husband's will, is basically minimal.
Great, great. So in that case, it's a situation, why it's set up that way is to avoid the entire process of going through the will, probate, etc. Is that correct?
Yeah.
Perfect, Mike. And I'm sorry, we do have to cut Mike off at that point. Hopefully that does answer your questions because we have someone else patiently waiting. We only have a few more minutes. Norm, go ahead, Norm. Norm? And I don't hear, is Norm, are you there? Nope, we don't have Norm up there right now. Yeah, we don't hear him. Oh, I know he's showing us he's still on the line. If he comes back, we'll come and help him.
Okay.
But that's a very interesting concept where, and hope Mike's still watching on this, where there are ways to avoid probate, essentially,
Yes,
or
there
estate
are.
tax. You know, that's probate's the old word. But so what are other ways? What are the rights that Mike would happen to have in that scenario?
Well, I'm not quite sure how the Henson Trust figured in that, unless he was going to be the recipient of the Henson Trust. But in that case, he would get whatever the instrument was. He said he had right of survivorship. I don't know whether it was a bond or it was something where it might even been an RRSP. You can name, if you've got a TIFSA, one of these tax-free savings accounts, or a registered savings plan, or a RIF, an RIF, you can name a beneficiary. It's called a named beneficiary, and that asset automatically goes to them. So if you leave everything in your will to your wife, but you've got a brother that you like and you name him as a beneficiary on your TIFSA, your RSP, or your RIF, he gets it regardless of what your will says. So you have to look at each asset individually first, and only if there's no named beneficiary does it go through your will. And then you look at the will and it says, I'll leave everything to my wife or my kids. They get all of those assets that aren't specifically spoken for ahead of time.
Okay, interesting. Now, there is, since we do have the time right now, we've about a minute and a half left.
Okay.
Let's say someone passes away, they have no will in place.
Right.
We were talking about what happens then. Quickly, could you let us know what happens and what is considered by the government when they get your hands on
so
them?
the Succession Law Reform Act dictates if someone dies without a will and they're married, the first $200,000 goes to the spouse, and the rest gets split 50% to the spouse and 50% to one child if there's only one child. If there's more than one child, the rest gets split 1/3 to the spouse and 2/3 to the children. Now, if you look at my website, and I think it went up on the screen, it's www.tonybakerlaw.com. I have a little article that I wrote for a hospital, and it spells out exactly what happens if you die without a will, how everything gets distributed, how it shakes down.
That's excellent, because we have about 20 seconds left. So I doubt we'd be able to go through all the process because it is complicated. And that's why you do need a lawyer, but there are some great resources. About 15 seconds, we have your website. Does it refer to other websites as well with the government that people could refer to?
There's some links on it, and
We have 4 seconds
we're out?
left.
Okay.
Visit his website and we'll get some links up there for you.
Okay.
Thank you so much. That is all the time we have today. Thank you to our viewers at home for your questions and comments, and thank you, Tony Baker, for helping Torontonians make sense of the law. Remember, know your rights, and if you don't, then watch us next time to get some free legal advice. After all, the best things in life are free. I'm your host, Natalka Faulkner, and thank you for watching Toronto Speaks Legal Advice.